Good evening. My name is Catrina Aquilino, supervising attorney with Community Legal Services of Prince George's County. I want to welcome everyone to the live view. If you have any questions, just put them down in the chat and I will do my best to respond to all of the questions that we have here live. If you're watching this video after we've gone live, please feel free to reach out to us. I'm going to have all of our information at the end of my presentation, and also you may see some of that information come up on the bottom of the screen from time to time with our contact information. You can either give us a call at 240-391-6370, or you could email us at info at CLSPGC, that stands for Community Legal Services, Prince George's County.org. So once again, info at CLSPGC.org. So I wanted to let you guys know that I'll be speaking about expungements and shielding in Maryland tonight. And also let you know about a really important clinic that we'll be having this Saturday. I know it's Halloween, but we'll also have a clinic from 10 a.m. to 1 p.m. It's all going to be virtual. And anyone that would like to meet with an attorney one-on-one at no cost to yourself to see whether you have a right to expunge a Maryland criminal case, you can just register for the clinic. You can register either today or tomorrow, and we'll set you in for a virtual one-on-one clinic. It'll be through Zoom, and I'll have that information at the end of this video. So right now, I'm going to share my screen, and we are going to start in on expungements in Maryland. So just bear with me while I pull up my presentation. I do apologize, everyone, for the technical difficulties here. I may not be able to share my screen with you tonight, but worry not, I will share all the information with you. So just bear with me. Okay, so I do apologize for that, and I was not expecting that. Apparently, StreamYard has informed me that I have an old computer. But like I said, don't worry, we will get through this as best we can. I will attempt to bring up the program or my presentation with the help of our communications coordinator who is in the background. But in the while we wait for that, I will just jump on into the presentation. So like I said, we are talking tonight about expungements and shielding in Maryland. The first thing that we're going to talk about is what is an expungement? Do apologize. Okay, so in Maryland, there are a number of different types of ways that you can remove from public view information about certain types of cases. The bulk of what we're going to be talking about today, and I want to thank you to Jordan for getting the presentation up on the screen. I do appreciate that. So the biggest one is expungements. Expungements are just for criminal cases that are where a person could be facing potential jail time. And shielding are for certain types of criminal cases, as well as certain types of protective and peace orders. And then sealing is any other type of case where you're trying to remove certain information from the public view. Now, expungements or the removal of criminal records from public inspection, including from court and law enforcement records. What that means is in Maryland, under Maryland law, if you have a criminal record, whether it's an arrest, a charge, a conviction, if it's eligible for expungement, then you can legally say that that crime never happened. Shielding keeps some information from the public. Expungement destroys the entire file. But shielding, well, that's the goal of expungement, but shielding is when there are the cases still exists in the court record, but some of that information is no longer accessible by the public, which in today's day and age, that would be Maryland Judiciary Case Search. I'm sure many of you are familiar as to what that is. So shielding would remove that information from case search. And then sealing limits the inspection of a case record. Okay, so next slide, please. All right, so expungements. There are two ways that you can file an expungement. Either one of those is going to be a petition, but there are two really big differences. One is those types of expungements for cases where you are not convicted. There's no guilty, it's called disposition. So anything but a guilty. That's going to be acquittal, dismissal, probation before judgment, nolle prosequi, stet, not criminally responsible. The rules are a lot different than those petitions for guilty dispositions. And we're going to get into what the details are for the two different forms. Next slide, please. Okay, here is just to give you an idea of what the expungement petition looks like for a case where you have not gotten a guilty disposition. Next slide, please. And we could back up one. Then there's the form for an expungement based on a guilty disposition. Next slide, please. And here is a general waiver and release form. That is required for cases where it's not been 3 years from the date that you got the disposition. So if you went to court and you resolved the case within 3 years, And you are eligible for an expungement, let's say for a nolle prosequi, where the state decided they're not going to go forward with the case, they're just going to dismiss it. If that happened, say 6 months ago, you can get the case expunged now, but you would have to fill out this form waiving your right to sue anyone that might have been involved in the case. And that's generally because state statutes of limitations are normally up to 3 years. So the court, or the reason behind not letting you expunge a case that's less than 3 years old is to avoid destroying a file when when you may still have a right to sue. So in order to get rid of those newer cases, sometimes you do have to fill out a general waiver and release. Next slide, please. Okay, so now we're going to go in depth into the expungement petition. There is no charge to expunge a case in which a disposition is either said acquittal or not guilty, and that's for the circuit court. If you're filing a case in the circuit court that is and not guilty, you don't have to pay $30. But if it's something else in circuit court, whether it's a dismissal, a guilty, what have you, you have to pay $30. In the district court, however, so long as you did not get a guilty disposition, you do not have to pay a filing fee. But even if you have to, even if there's a required filing fee, if you do not have the money to pay that, you can fill out a fee waiver form to avoid having to pay those fees. And like I said at the beginning of the conversation tonight, we will be having an expungement clinic this Saturday from 10 to 1, and it's going to be virtual. And you will be able to meet with an attorney one-on-one. And one of the things that attorney can help you with is doing the fee waiver form if you need it. Next slide, please. Okay, so now here's where we're going to get into the detailed information. So when can you get an expungement? Now, everything is fact specific. So what I say here we'd have to look at your entire cases. I will start off by saying that in order to have your cases be expungible, in order to actually be able to file the petition, you cannot have any open criminal or serious traffic cases where you could potentially go to jail for. You can't have any open cases of those type. Now, if you have a dismissal, so a nolle prosequi, you can get that expunged immediately. You don't have to wait any time, but you do have to file the waiver form. If you get a not guilty, again, you can file that at any time, but you do have to do the waiver form. Probation before judgment. If you have that, you have to wait 3 years from the disposition date, meaning that the day that you got the probation before judgment, or the date that you finished up probation, whichever is later. So that's really fact specific, but don't worry, an attorney can help you read case search, read what happened. If you have that information, great. But even if you don't, we can probably help you out to figure out when your probation before judgment might be expungible. The only difference here, or the only caveat here, is that if you were found guilty in another case after you got the probation before judgment, within 3 years after getting the PBJ, meaning probation before judgment, you would not be able to get to the PBJ expunged unless you would be able to get that guilty conviction shielded. And I know it gets really confusing, and you don't have to understand, you don't have to memorize all the different rules, because that's where we come in. The other thing that I will say is for a probation before a judgment, almost any PBJ is expungible if it meets those requirements, except for a DUI. That is a PBJ is not expungible, unfortunately. All right, so now we go to a stet. You can get a stet expunged, but it has to be 3 years, at least 3 years from the date that the case was placed on the stet docket. Now, a guilty verdict of misdemeanor minor common nuisance crimes would be 3 years after you were convicted or after you completed your probation sentence, whichever is longer. Now those are very specific, the common nuisance crimes, but don't worry, we can help you out with that. A not criminally responsible, that I believe may not be accurate. So we're just going to move on from there. The nolle prosequi is just like a dismissal, it is immediately expungible, but you do have to file the waiver. The no, sometimes you might hear a nolo plea or nolo contendere plea. That is not eligible for expungements, because in many different ways it's treated as a type of guilty plea. In many ways not, but for purposes of the expungements, you're not able to get that expunged. Shielded cases, it's very difficult to get those expunged. And most of the time, if you shielded a case, it's probably because it's not eligible for expungement. If you had a case where you were charged as an adult, but the case later got transferred to juvenile court, that you can also file to get expunged immediately after it's been transferred. Again, provided that you have no open cases. And then if you have a governor's full and unconditional pardon, you can get that expunged immediately from the date it was signed by the governor of Maryland, but it must be done within 10 years from that date. Essentially, you'd have to do it within 10 years of getting the pardon, or you won't be able to get it expunged. Next slide, please. Okay. So, now we're going to go into a little bit more tips and when are you not entitled to an expungement. So most other guilty convictions other than certain nuisance crimes, you're not going to be able to get expunged. I will say, however, that there is a big exception to that, but it's complicated as to where you can look to find it, and we'll get into it a little bit later, but again, don't worry. That's where we come in, and if you do have any questions with that, we can set you up with an attorney for our clinic that's going to be happening this Saturday. And if you miss the clinic for this Saturday, don't worry, because we have another clinic scheduled for 2 Saturdays from now on November 14th from 10 to 1. So again, so if it's a guilty other than a common nuisance, then it's going to be harder for you to get an expungement. If you had a PBJ and you've been convicted of another crime within the 3 years of getting the PBJ, or you had a DUI, it's going to be very hard for you to get an expungement, if at all. You have to have you can't have any open criminal or serious traffic cases. And here's a big thing that people don't think about. So when you get charged with a crime, a lot of times you have more than one charge, and that's in a case. So you may have one case, but multiple charges. And you may be only convicted of one of those charges in the case. The unit rule means that if you were convicted, if you have one charge that is not expungible in the case, the entire case is not expungible. So what does that mean? Say a person is charged with armed robbery and armed robbery, robbery, assault, and theft. And they are only convicted of the assault charge. If the assault charge will prevent them from getting expunged up to a certain point, so that means that the armed robbery, the robbery, and the theft charge are not going to be expunged either, even if all of the rest of them were dismissals. At a certain point, the assault might become expungible, and we'll talk about that a little bit later. Then again, this expungements only apply to criminal and serious traffic cases, things you could go to jail for. So if you're charged with minor traffic offenses, meaning things you can't go to jail for, so speeding or what have you, you cannot get those charges expunged, at least not through this process. You have to petition the MVA, and that's a different process. Next slide, please. Okay. Now, the only when you fill out a petition, you have to include just that one case number or one series of traffic cases per petition. You can't you can't put more than 2 cases on one petition. But if there are multiple charges within that one case, you can you don't have to do separate petitions for the different charges as long as it's within one case. And you don't have to worry about getting the expungement petition notarized. It is just a form that you sign as the defendant, and if you have to file a general waiver and release, you sign it as well, and you sign it in front of a witness who also then has to sign it as the witness, but neither form needs to be notarized. Next slide, please. Okay, now how long does the process take? So say you have an appointment with us this Saturday. We fill out the form. An attorney helps fill out the forms for you. They get you the form. You have the forms in hand. You file it with the court. How long does it take from the time that you file it with the court? Normally, it's going to take about 90 days. Now that you should get an order from the court saying when your case is expunged, or when the court orders that it be expunged from the various entities that may have a record of it. If the court denies the expungement petition, you may appeal the denial within 30 days. Now, I will say that depending on where you're filing and the reason why you're filing for the expungement, the state's attorney may ask for a hearing, or the court may set the case in for a hearing. It normally doesn't happen, but it may happen, and that's going to delay the process. There is a certificate of compliance, and that is that the court has complied with the order and notified the parties on the form. And your record has been cleared of the charge once you receive a letter of compliance from each of the listed parties of the court in the court order. After the expungement order, the public will not be able to view records on case search. That's after it's expunged, and the court's arresting agency, parole and probation, criminal justice information services, FBI, and each have their own database. Each entity will expunge their own database. It's going to be very important for you to always keep a copy of all the expungement documents and expungement order, since they may be needed for future reference. Once the case is expunged, all documents pertaining to the case will be destroyed. Why is that important? Well, as you see, each particular agency has to expunge their own records. And we live in the internet age. What that means is that there very likely may be some evidence that the case that you're getting expunged did exist at one point in time. But what you want to have is a certified copy of your disposition sheet, and that is to show that what happened with the case. So a certified copy of the disposition sheet, and a certified copy of the expungement order. You want to have those so that you can prove to whoever is asking about it, about why that case existed. You want to be able to prove what happened. The fact that whatever the disposition was, and the fact that, excuse me, it was expunged at a later date. And if you do not get the certification now, or the certified disposition sheet now, and you wait until after the case has been expunged, it may be too late, because the whole point of the expungement is to get rid of the court case file. Next slide, please. Okay. So if you are not a U.S. citizen, it is advisable that you do not file for an expungement unless and until you become a U.S. citizen. The reason why I say that is there may be certain immigration consequences that can come from expunging the case, and not necessarily a direct consequence, but a lot of times the USCIS is going, the immigration, United States Customs Immigration Services is going to want to know what happened with any particular criminal or traffic cases. And if you have expunged the file, expunge the case, you may not have the evidence that they need in order to process your paperwork. And for that reason, amongst the others, it's advisable that if you are not a U.S. citizen, that you do not expunge a case. But if you have questions, by all means, come in, make an appointment with us for one of our clinics this Saturday or on November 14th, so that we can talk to you specifically about your case. Next slide, please. Okay. There are a lot of different ways to get help with expungement questions. Like I said at the beginning, I work for Community Legal Services of Prince George's County. And you see that we're here on this screen. There are a number of other organizations that may be able to help you. Maryland Volunteer Lawyer Services, Maryland Office of the Public Defender, other organizations as well. You can represent yourself if you want. You do not have to meet with an attorney in order to fill out the petition. You can get the petitions online. You can watch videos online, even refer back to this video if you need it in order to see, to get some help to fill out the petitions if you wanted to represent yourself. And then also you see here some information about the MVA, the Criminal Justice Information System. So do refer to this list. You can always pause the video while you're watching it and take that information down, and contact the various resources when you need them. Next slide, please. All right. Now, remember when I talked about how certain guilty convictions may be eligible for expungement later on? Well, here's some of them. I'm not going by any means to go through this list. It is very long. I think it's another 2 slides after this. But essentially, the rule is this. Outside of what we talked about before, if you have a guilty conviction, it used to be, prior to these new rules, well, they're not new now since they're from 2017 and 18, but prior to that, if you had a guilty conviction, the only way, outside of the nuisance rules, the only way that you could get an expungement would be that if you got a pardon, and those are very hard to come by. Not impossible, but harder. These rules, however, make it so that if you have one of these misdemeanor convictions, and you have gone 10 years from the date of the finishing up your entire sentence, so that means off probation, off parole, not in jail, nothing like that. 10 years from the date of that, of finishing up your entire sentence, um, and then you may be eligible to get that guilty expunged. It does, depending on what other cases you may have, it may affect that. But the rule generally is that if you have a guilty, and it's one of these rules here, it's been 10 years from the date that you finish up the entire sentence and you have no other guilties after that that are not expungible, or no other cases after that that are not expungible, then you can get these cases expunged. There is a different a rule specifically for assault, that if an assault involves a domestic issue, then it will be it, it'll be 15 years, as you can see on the screen when it talks about second degree assault. But next slide, please. You can see that there's a bunch of other ones here as well. And again, there, you can go to the next slide. Like I said, I'm not going to read all of these. It is very fact specific. That's one of the things that the attorneys at our clinics this Saturday or on the 14th can help you go through. So I do encourage you to register and take a little bit of time out of your Saturday to meet with an attorney and see what cases you have may actually be expungible. Now, next slide. Okay. So, what we just talked about were guilties for misdemeanors. Well, there are now, from 2018, certain felonies. It's not a lot of felonies, so we are going to talk about which ones they are, but certain felonies are now eligible for expungement so long as you've gone 15 years from the date you finish up the sentence, the entire sentence, no more jail, no probation, no more parole. You finish up the entire thing. If 15 years have passed and you have no new cases, that would be not expungible. If you have been convicted of a felony theft, felony possession with intent to distribute a controlled dangerous substance, or a felony burglary, whether it's first, second, or third degree burglary, any of those ones may certainly be expungible. And that's a really big deal. It's not as many cases that we would like to see, but it is a lot better than it used to be. So even if you do have a guilty conviction now, you very well may be eligible for an expungement. So come on, make an appointment, and we will see if we can help you with that. Next slide, please. All right, so we kind of finished up the expungements. I do encourage you, if you know, if you think you may have some cases out there, set an appointment. If you know of family members or friends that need that could benefit from this, let them know about our services. They can fill out the form online. You can use your phone to fill out the form, and then use your phone to meet with the attorney on Zoom. And we do hope that we'll see a lot of you on this Saturday. Now we're not gonna go in as a detail with the rest of the shielding and sealing, but I do want to talk about it just briefly so that we can talk and get it out to get the information out here. And so for shielding, there are 3 types. There are certain crimes that are not expungible, that most of them are not expungible. You may, however, shield them from public view. The catch is that you can only do a shielding once. It's under the Maryland Second Chance Act. And then it'll be removed from case search so people can't see it. It's not as good as expungement, but it is helpful for certain individuals. Then for shielding of protective and peace order cases, certain cases, once the order has completely ended, the respondent may be able to ask the court to remove those documents from public view, from case search and whatnot. And then, of course, if you are a victim or a witness in a criminal case, you may be able to shield your address or telephone number. Next slide, please. Okay. And for criminal convictions, we'll go a little bit over that, but not too much in detail. Next slide, please. Here you can see the criminal convictions that can be shielded. And as you can see, it's not an expungement by any means, but it can be make your case not accessible by the public, and you can see what those types of crimes are. And again, if you want to look into that in more detail, you can just pause the video right now and look at those. But you don't have to memorize that. You can always ask one of our attorneys. Next slide, please. Okay. Just a couple of pointers that a domestically related crime cannot be shielded, and those are crimes committed by a defendant against a person eligible for relief or a person with a sexual relationship. Now, again, you can always ask one of our attorneys, and we can help you figure out which whether your cases are domestically related or not. Next slide, please. So you must wait 3 years from the time the sentence is completely ended, meaning jail, parole, probation, what have you. You have to have no other open cases, and like I said, it's a one and done type of option made available to you. Next slide, please. Here's just so you can see what one of the petitions would look like for shielding a criminal conviction. Next slide, please. And the circuit court and district court have different forms, and this is a guide for your case. Next slide, please. Okay. Under certain circumstances, records shielded under the Second Chance Act can be accessed by certain parties, and that's one of the reasons why a shielding of a criminal case is not as good as an expungement, because the case record still does exist for someone to look into, whereas with an expungement, the goal is that the court destroys the file. Next slide, please. Okay, now for protective and peace order cases, those can be shielded as well. It's the respondent who normally asks for a case to be shielded, and they can request that it be shielded only when the case was dismissed or denied, or the case was the respondent consented to the final order, and the order has since expired, and there's been no further incidents between the petitioner and the respondent, and there's been no conviction out of the act of abuse. A petitioner can request that his address and his name be shielded. Next slide, please. Okay. In order to request the shielding, the respondent has to wait 3 years from the denial or the dismissal and do a general waiver and release, meaning they agree not to sue any party involved. And like I said, there can't be any other final peace or protective orders between the two parties, and no criminal conviction or pending charges between the two. And that's for dismissed ones. For consented to ones, still have to do the general waiver and release if it's within 3 years from the expiration of the order. Must have no violations of the order, and no criminal convictions or pending charges or other final protective or peace order cases between the parties. Next slide, please. Here's just so you can see what a petition looks like for shielding the denied or dismissed orders. Next slide, please. And here's for the consented orders. Okay. Now, as far as a respondent requesting to shield a peace order, it's a very similar process to a protective order. It just happens to be a difference of the relationship between the petitioner and the respondent, which I'm not going to get into here. But if you are interested in knowing what the difference is, you can always contact us at Community Legal Services. Like I said, at the end of the stream, I'll have our contact information on one of the slides. Now, that's fine. You can move on. Like I said, the peace order and the protective order process for shielding is very similar, except it's a little bit different. So here would be the denied or dismissed peace order shielding. Next slide. And here would be for the consented to one. Just important to know that you're filling out the right form. Next one. Okay. Now, shielding a petitioner's address in a protective or peace order case, it's relatively simple. Next slide. The petitioner just needs to make a filing with the court and explain why they want that. Next slide. It's a very similar process for shielding a victim or witness's address and phone number in a criminal case. Next slide, please. They would just fill out this form and request it of the court. Next slide, please. All right. Now, sealing case records. It's a very different process from expungements and shielding. This limits access to what documents from a case record can be examined by the public. And it's extremely different, mainly because with expungements and shielding, it's like a formula. If your conviction or if your disposition was a certain type, then you either are or are not eligible for expungement. Sealing, it's different. Next slide, please. It would apply to any other type of case record that we haven't talked about with the expungement and shielding. So that could be an exhibit, a complaint, another filing, and it could be a civil case or an equity case or what have you. Next slide, please. There is a form that you could use to ask the court to seal the case. It's by no means guaranteed that you that the court will grant it. Unfortunately, we will not be able to give you a consultation on sealing case records on this Saturday or at our expungement clinics. But I did want to just touch upon this because since we're talking about expungements and shielding, some of these questions may come up. Next slide, please. Vacator laws are very important. It's very limited at this point in time, unfortunately. But a vacator law is a motion to vacate the judgment for acts of prostitution committed under duress in Maryland. It could at some point in time be expanded to include other types of crimes, but now it is for prostitution and convictions vacated if shown to be related to duress and other requirements. This is mainly where you're looking at individuals coerced into performing acts of prostitution. There's no court form pre-made, and it should be by motion. Next slide, please. Here's just a sample type motion, so you can see what it might look like. But if you're going to do a vacator law or vacator request, I do recommend that you meet with an attorney prior to that. Next slide, please. Okay. I do apologize. There is I had done up a last slide, but given my my problems with the computer earlier, it's not coming up. I will, however, share the information with you now, and that is that we have a clinic, how you can get help. We have a clinic this Saturday on Halloween, October 31st, from 10 a.m. to 1 p.m. And you can register by going to a Google form that we have. It's a bit.ly/, capital letters CLS, then capital O, lowercase ct, numerals 31. I will try my best to put that into as a comment to this video so that you'll have that, but it's a bit.ly/capital letter CLS, capital O, lowercase ct 31. Please go there if you think that, even if you just want to talk to an attorney and see what your case might be eligible for. It doesn't cost you any money. It's completely confidential, and whenever you talk to the attorney about, and they can help walk you through this. They can, and if you are eligible for expungements, they can help you fill out the forms and instruct you on how to file and what the process will look like for you specifically. If you have any other questions related to any other areas of the law, or you can't make it to this clinic on Saturday, please reach out to us. You can go to our website, clspgc.org, to apply for services. You can fill out a form on our website. You can email us at info@clspgc.org. You can call us at 240-391-6370. Once again, 240-391-6370. Please reach out to us. And I do really encourage you guys one last time to just come on and make an appointment. Share this video with any friends or family that you may have. Expungement, it is a great tool that you can use to help get rid of some harmful information that's on a public website. And so please, if you think this might be useful, just fill out the form and have a consultation with us. With that, I will end the presentation tonight. I do apologize for my technical difficulties there. I do need a new computer, but I do appreciate all of your guys' patience. And if you have any questions, just give us a call. I hope you have a good evening, and I hope to see you all on Saturday. Bye.